Our phone lines are open, so please call us with your questions. You may also email those questions to open@ncmail.net, or you may use the following numbers to telephone or fax your questions. Our next speaker, Kimber Scavo, will discuss plans for implementing the 2008 ozone standards. Kimber?
Thank you, Jenny. Hi, my name is Kimber Scavo. I'm the group leader of the State and Local Programs Group in OAQPS. Our group is responsible for implementing all of the NACs. Rhea Jones's group, the Geographic Strategies Group, is responsible for ozone designations. Earlier in this broadcast, Lydia Wegman presented a timeline for new ozone designations, as well as a general indication of important SIP and attainment dates. For designations, we intend to provide additional information to the states and tribes concerning the technical considerations for establishing boundaries. We do anticipate relying mostly on past ozone designations guidance that we issued in 2000. We will work closely with states and tribes on establishing new guidance if needed. For SIP due dates, Lydia mentioned that the attainment demonstration SIPs will be due in 2013. Also, note that there are Section 110A1 infrastructure SIPs that are due no later than March 12, 2011. These SIPs provide assurances of state resources and authorities and establish the basic state programs to implement, maintain, and enforce new or revised standards. The 2013 SIPs are required for all non-attainment areas and are due no later than 3 years from the date of final designations. We plan on issuing a proposed rule this fall to establish the specific SIP due date and how attainment demonstrations, attainment dates, classifications, reasonable further progress, NSR, conformity, and other implementation requirements and issues apply to the revised 2008 ozone NACs. I will now go over a list of our planned rulemakings for the 1997 and 2008 ozone standards. I want to mention that as we are looking toward implementing the 2008 standards, we need to consider what is happening with the 1997 standards. For now, the 1997 8-hour ozone NACs and all the associated requirements will remain in place. States should continue their plans for implementing the 1997 NACs. As most of you know, on June 8, 2007, the U.S. Court of Appeals for the D.C. Circuit responded to our petition for rehearing on the Court's December 22, 2006 decision on our Phase 1 rule to implement the 1997 8-hour ozone NACs. The Court upheld the portions of the Phase 1 rule relating to EPA's classification system under Subpart 2. So classifications for Subpart 2 non-attainment areas, attainment dates, and the timing for emissions reductions needed for attainment of the 8-hour ozone NACs remain in place for the 1997 standard. The Court also urged EPA to promulgate a revised rule to implement the 1997 ozone NACs for all unresolved issues as quickly as possible. The next steps on the 1997 ozone NACs for us are to develop proposed rules to address classification of Subpart 1 areas, as well as anti-backsliding requirements for new source review, contingency measures, and Section 185 fees for the 1-hour ozone NACs this fall of 2008. We are hoping rules for all of these issues will be issued by fall of 2009 for our final rulemaking action. At the same time, for the 2008 ozone NACs, we will be developing a proposal on transitioning from the 1997 standards to the 2008 standards either this fall of 2008 or winter 2009. Right now we are gathering questions to address in this proposal from states and tribes. This will give you an opportunity prior to proposal to get your questions to us for addressing in the proposal. If you do have these questions, please send them to Mr. John Silvasi. His number and email are located on the slide. That is the latest information on ozone implementation that we have right now. Stay tuned for all of our upcoming proposed rules, and we look forward to working with you. Thank you.
Thank you, Kimber. If you have questions on implementation, Kimber will be joining our live panel at the end of the broadcast. Now let's hear about monitoring from Lou Weinstock.
Thanks, Jenny. EPA recently finalized revisions to the ozone NACs. Although no specific changes were proposed or finalized for the accompanying ambient monitoring rule provisions, comment was solicited on several topics that will help inform the path forward as EPA prepares a separate proposal on ozone monitoring. I would like to take a few minutes to summarize our thoughts on this issue so that people will be in a better position to comment on our proposal when it is published this summer. As we stated in the Ozone NAAQS final rule, we are committed to a separate rulemaking to address ozone monitoring issues. We received many helpful comments from states, monitoring organizations, environmental groups, and industrial organizations during the Ozone NAAQS proposal process, and those comments will help us to propose specific changes to the ozone monitoring rules that are consistent with our own technical analysis, as well as some of the comments received from the public. A few of the key comments are summarized on this slide. The areas that commenters focused on were urban monitoring requirements for smaller communities, rural monitoring requirements in areas where EPA has not traditionally required states to operate monitors, and issues regarding the length of the required ozone monitoring season. A bit more detail is provided on each of these areas in the ensuing slides. EPA currently requires ozone monitoring in many communities with urban area populations of 50,000 people or more. Most of those areas, which can also be categorized as CBSAs or core-based statistical areas, have very adequate ozone monitoring systems that are operated by states, local agencies, or in some cases tribes. However, we have identified a segment of these communities with populations ranging from 50,000 to 350,000 people that are not currently required to add monitors if such monitoring does not already exist. Given the tightening of the ozone standards, EPA believes, and public commenters agreed, that we should consider new requirements for these currently unmonitored areas. We have identified approximately 100 areas that could be subject to these new ozone monitoring requirements. Those areas are highlighted in pink on this map. The highlighted areas are also surrounded by color-coded markers showing the design values of nearby monitors. We have observed that many of the nearby monitors are recording ozone values that exceed or approach the level of the tightened standard. We think this indicates the potential for elevated ozone levels in the unmonitored areas and highlights the need to fill these gaps in our urban monitoring network. We also think that flexibility should be provided in these proposed requirements, and we expect that states would work with their EPA regional offices to determine where new monitors should be installed and where it might not be a good use of resources to do so. The monitoring proposal will outline the basis for such discussions. EPA currently does not have any requirements for rural ozone monitors. There are, however, over 200 non-urban ozone monitors that are being operated by federal agencies, including EPA and the National Park Service, as well as state monitoring organizations. These ozone monitors are located in less populated urban and suburban communities, in truly rural areas, and in some national parks and similar areas of protected land. EPA is considering new rural ozone monitoring requirements in the upcoming proposal that could lead to the establishment of some new monitors, as well as extend federal monitoring requirements to the existing monitors that are not currently part of official state networks. These new requirements would help ensure EPA regional office oversight of rural monitors, the inclusion by states of such monitors in publicly available annual monitoring network plans, and provide for a more consistent application of quality assurance requirements. This map provides a sense for the distribution of non-urban ozone monitors, with the red dots indicating actual monitoring locations in relation to green areas, indicating federal lands, state parks, and other protected areas. We note the relatively high density of these monitors in the eastern half of the United States and in California, with large spatial gaps without rural-type monitors in the Plain States and across the Pacific Northwest. As those of you who operate ozone monitors already know, in many parts of the country, the operation of ozone monitors is not required on a year-round basis. Instead, EPA requires ozone monitors to operate on a seasonal basis that is specified for each state. These seasons are based on meteorological conditions and historical reviews of ozone levels in each state to ensure that monitors operate when ozone levels are likely to be near the level of the standards. The length of the ozone seasons was reviewed in the late 1990s when the form of the ozone standard was changed from a 1-hour average to an 8-hour average. While a few state seasons have been modified through EPA regional office discretion or rulemaking, there has not been a systematic review of ozone seasons in some time. We believe that now is an appropriate time to be reviewing this issue in light of the recent revisions to the levels of the ozone NAAQS. To support this effort, EPA statisticians are looking at the frequency of ozone exceedances of the revised NAAQS level that occur outside of the currently mandated ozone season. We are looking at the occurrences of elevated ozone levels in the context of the recently revised Air Quality Index breakpoints to make sure that ozone monitors are operating when highly sensitive individuals might be affected by levels in the moderate category of the AQI. This map provides a color-coded overview of the different ozone monitoring season requirements currently specified in our regulations. 5 states are required to operate their ozone monitors on a year-round basis, while other areas have generally shorter operating seasons based on climatology and the previously mentioned analysis of ozone data. Interestingly, we have found that many states voluntarily operate their ozone monitors year-round. These discretionary monitors have been very helpful in demonstrating the inadequacy of the currently required seasons in some cases. We will provide specific state-by-state information in the ozone monitoring proposal on the ozone season issue, together with our rationale for why some states may need to have their seasons lengthened to support the revised NAAQS and the AQI. Once the ozone monitoring proposal is signed and published, there will be a public comment period to receive input on the proposed rule. We encourage everyone to participate. While all submitted comments are read and considered, we especially value those specific comments that are submitted by organizations directly involved or familiar with ozone monitoring issues. These specific comments help provide a legal and technical basis for improving EPA's proposal and ultimately help support an improved final monitoring rule that serves the needs of the entire monitoring community. Please stay tuned to EPA's rulemaking schedule and any specific announcements regarding the pace of the ozone monitoring rulemaking effort.
Thank you, Lou. Let's take a 5-minute break, and we will return with our live panel to answer your questions. If you've not already sent in your questions, please send them in now to open@ncmail.net or call or fax to the numbers on your screen. We will address as many questions as time allows. Before we break, here's the trivia question for today's broadcast. We all know that the Air Quality Index is an important tool in educating the public about air quality in their neighborhood. What was this index called before it became the AQI? The first person who submits the correct answer wins a prize. Let's take a 5-minute break, and when we return, we'll be with the live panel.